Hello and welcome to Legalese. I'm Ernie Hyde, your host, and we're going to be talking a bit about bankruptcy myths today. And to help me do that is going to be Mr. Robert F. Casey Jr. Bob is an attorney in Harvard, Mass. And has been doing bankruptcies for, do you want to say how many years?
About 3 decades anyway.
A long time.
Yeah.
And so he's well versed on bankruptcy and especially the new changes in bankruptcy over the last couple of years. So let's start off with one of the myths that I hear quite frequently. I have a number of credit cards. They're almost all maxed out except one. I want to keep that one because I travel on business. I don't want to lose it. So I'm going to pay that one off and we'll let the other ones go in the bankruptcy. What do you get to say about that?
Well, that's a myth that needs to be debunked. First of all, it's wrong on a few levels. First of all, depending on how much the payoff is, it could run afoul of what's called preferences. The bankruptcy law is a very comprehensive statute, and it says that if you pay more than $600 to any one creditor within 90 days of filing, that could be deemed a preference and called back from that creditor. Now, that's called back from the creditor. It also is not looked upon with a great deal of favor, making payments on the credit cards right before you file. Also, it really doesn't even meet your purpose as well. Since the electronic integration of the bankruptcy system, creditors can very easily get a hold of the bankruptcy filings. So as a practical matter, if you file, and even if you have a zero account balance, it's highly likely that that credit card is going to be canceled anyway.
Okay.
So you'd probably just be throwing money away by doing this.
Okay. But let me also bring up the point of getting a credit card after bankruptcy because people do need credit cards to function with nowadays if they use them wisely, at least. What's the possibility?
Well, first of all, you're right. People really do need credit cards. If you go to New York City and try to rent a car, if you don't have a credit card, you just aren't going to get one.
Or a motel room, a hotel room, right?
Exactly. So you need something along that line. The reality is that even immediately after a bankruptcy, you should be able to get a credit card. They used to be called secured credit cards, where you'd have to deposit a certain amount of money. Capital One and others were one of the first innovators in this regard. Deposit money, it would stay in the account for a year. If you paid your credit card bill faithfully, then they would allow you to withdraw the money. But they've even done away with most of the secured credit cards. They'll just give you an unsecured credit card. Apparently the payment history has been reliable enough. They know people need a credit card that they will take the shot with them again.
Well, logically speaking, you and I were talking just before we came on, the person who filed bankruptcy's in much better position at that point because they have no debt after the bankruptcy anyway.
They have no debt, and also technically they can't discharge the debt for another 8 years. So if the creditor is going to be very cynical, the creditor can take the position, well, we've got a very good risk here that someone that can't file for bankruptcy relief for another 8 years. But as a practical matter, most people that filed bankruptcy, they didn't want to file. They did it as a necessity.
Right.
And if they had the money, they would have paid the debt. There's no doubt about that. So if they obtain a bankruptcy discharge, they're going to be, as a rule, they're pretty cautious going forward. So the creditors know it's a good risk.
Okay. The other myth is I have to have a lot of credit card debt to file bankruptcy.
Well, certainly credit card debt is one of the reasons that people file bankruptcy. There's no doubt about it. It's got to be one of the major reasons for bankruptcy filings, but there are many other reasons. I mean, there are even tax debt. If you have income tax debt that is overwhelming, if it's old enough, you may be able to discharge it straight out in a Chapter 7. If you're having trouble with the IRS harassing you and trying to collect, or even Massachusetts Department of Revenue, you can file a Chapter 13 under certain circumstances and can control the flow of the payment plan, the repayment plan. Chapter 13 is also used to help people catch up on mortgage arrearage if they were laid off or had an illness and were out of work for a period of time and got behind on their mortgage. Chapter 13 allows those folks to hang on to their home. Congress made the decision they didn't want to see people lose their home because of a temporary illness or temporary loss of employment. It gives people an opportunity to take care of the arrearage, not in 3 or 4 months. It can be stretched out as long as 5 years if needs be.
Mm-hmm. Okay, great. Another myth that I'll use my credit card to pay my attorney to do my bankruptcy.
Well, that would be a real mistake in a number of ways.
On whose part?
Well, first of all, if an attorney accepted a credit card payment, I think he might be sanctioned. Now, if it's a debit card, technically that's fine. But even I think I'd be nervous even with a debit card. Mm-hmm. But it would be a mistake on a number of levels. First of all, Section 523 of the Bankruptcy Code says that anyone who incurs a debt without the intention of paying that debt, it's non-dischargeable. It really goes to the good faith aspect of the Bankruptcy Code. The Bankruptcy Code really rewards those that in good faith got into trouble.
Right.
People that try to play the games, the Bankruptcy Code is designed to steer them away and deny them a discharge. Because the Bankruptcy Code really has evolved over hundreds of years of Anglo-American jurisprudence. So pretty much all the games that are known have been thought of, and the Bankruptcy Court has already seen them a number of times.
At least once.
Yes.
Right, right. Okay, well, that actually goes into my next one, is the notion that I'm going to run up all my credit cards to the max and then file bankruptcy.
Yeah, that's sort of like a cousin to the one that you just mentioned.
Right, right.
That one is really a clear violation of 523, knowingly incurring debt with no intention of paying. And that's just outright denial of discharge. Someone might say, well, how do you prove whether I had intent or not? Usually it's done by inference. They see a lot of credit card use, heavy credit card use just before the filing. There's going to be solid inquiry into whether that was good faith or not. So very, very risky proposition to do it. Technically, I think it actually crosses the line from not just denying dischargeability, but could actually be a criminal offense under the Bankruptcy Code. Mm-hmm. So it's a dangerous course of action.
Yeah, intent. Okay, if my mortgage is in arrears, I'm going to lose my house if I file bankruptcy, and then where am I going to live?
Obviously a concern, keeping the roof over your head for yourself and your family. Now, thankfully, the Bankruptcy Code has a lot of humane aspects to it. One of them is that there are exemptions. The exemptions are those aspects of the law that allow you to keep certain assets, file bankruptcy, and still retain those assets. The Bankruptcy Code allows states to allow their citizens either to take the state exemptions that are applicable in their state, the federal exemptions that Congress offers, or to opt to either. Massachusetts, thankfully, is an option state. So when you file bankruptcy, you can either take the state exemptions or the federal exemptions. Massachusetts has a very generous homestead exemption. That statute was just modified, I think, 2011, and it made the homestead law less complicated, and also it initiated an automatic homestead. You don't even have to record a document. You get a $125,000 automatic homestead exemption. Mm-hmm. What that means is if you take the difference between the fair market value of your home and any encumbrance payoff, mortgage payoffs, if it's $125,000 or less, you file for bankruptcy relief. It's exempt. The creditors can't touch it. The Chapter 7 or Chapter 13 trustee can't touch it. If you record a homestead declaration, you get the benefit of $500,000 in home equity.
Right.
That should cover just about 99% of the people that have homes.
Sure.
That's a lot of equity. So there's really a clear policy in the Commonwealth of Massachusetts that we want people to hang on to their homes. So bankruptcy, so long as you can make the payments, either through a 7 or if you need time to catch up on the arrears through a 13, yes, you can hang on to your home. And that's a strong policy of the bankruptcy code.
And that plays into my next question about losing the equity that you have built up in the home, and that's the 125 or the 500,000, depending on whether you record or not.
Exactly.
The homestead. Okay, tell me about the tax debt. We have this notion that all taxes have to be paid regardless, and bankruptcy is not going to do us any good when it comes to taxes.
A couple of things to talk about there. First of all, income tax debt is dischargeable under certain circumstances. Fiduciary taxes aren't. For instance, if you have a small business and you've been unable to pay your employees or haven't paid your employees withholding tax to the Commonwealth or to the IRS, that's going to be a problem. There's just no way to discharge that, ever. But if you have income tax and that income tax debt is more than 3 years old from the time, if you take the time from when you filed the income tax return, and 3 years has gone by to the time that you filed your bankruptcy petition, it is dischargeable. One of the things that I see that sometimes people don't file their tax returns thinking, oh my gosh, I'm going to owe tax debt. Best thing to do is to file the return. Get the clock running. If you don't file the return and file them all at once, then you have to wait 3 years before you can do it. Or there's more complicated formulas about when it's assessed. But I think a good benchmark is the 3-year benchmark.
Right.
So if you don't have the money, please file the return. It's best to get that clock running. And also, it prevents you from incurring other penalties as well along the way.
Okay. What about student loan debt? Another thing that we feel as though we cannot get discharged in bankruptcy.
That is a myth. Unfortunately, not as much of a myth as it used to be. Way back when I was a student incurring debt, it was sort of an ongoing scandal at that time. There were people graduating from college with student loan debt, and they immediately go out and file a bankruptcy petition and wipe it out. Congress got tired of that and amended it, the bankruptcy code, to say that there must be at least 5 years of good faith attempt to repay the debt, and then you could file. Congress then went to 7 years. Then it went to undue hardship. That's the standard now. Student loan debt can be discharged, but you must show an undue hardship. The way the case law has worked out in that area, it's really become a rather sheer cliff for someone to be able to discharge student loan. The standard has become harder and harder. You actually have to, within the bankruptcy proceeding, file what's called an adversary proceeding, which in essence is a suit within the bankruptcy. I've handled a number of them. I've discharged quite a bit of student loan debt, but it is a big task. Certainly, it's something, if there is a issue about student loan, it's worth consulting an attorney that's skilled in bankruptcy law. Generally, the first consultation is free of charge. They can tell you whether there's anything you can do along that line. And most attorneys skilled in that area can also, if it's not dischargeable, give you guidance on forward repayment plans and other things you can do to try to help with the student loan.
What about judicial judgments? I'm sued and I lose my case and someone wins $1 million judgment against me. Can I discharge it in bankruptcy?
Generally, the answer is yes. There are exceptions to discharge. Let me sort of answer the question in two parts. First of all, I think a lot of people are concerned that a judgment has more power than just a regular debt. If you have credit card debt and you're just getting dunning bills saying you owe it, they think somehow if someone's gone in, a credit card company's gone in and sued them, got a judgment, somehow that's more powerful. The answer is no. If it's a regular, generic, unsecured debt, bankruptcy discharges that as well as the debt that's just overdue. But it is worth keeping in mind that sometimes these judicial debts become judicial liens. A lot of times they're not just a judgment. They record the judgment, and it becomes a lien. Now,
Record against real estate.
Recorded against the real estate,
Right.
exactly.
Yep.
That can be avoided in most instances within a bankruptcy, either a Chapter 7 or a Chapter 13. But it's a little bit more of a complicated process. And as far as judgments, most judgments that most people are concerned about are dischargeable. Credit card, debt, medical bills, things of that nature. The ones that aren't dischargeable are wrongful torts. For instance, a judgment against someone for causing personal injury from while they're under the influence.
Something intentional. Or construed that way.
Construed intentional, and they've even stretched it to, even though most people under the influence are not intentionally hurting anyone, they're so reckless that they've made it an exception.
Okay. Yeah.
And then there are other exceptions but it's wise to consult with a bankruptcy attorney on that. But the starting point basically is don't fear the fact that there's a judgment. It's very likely dischargeable.
Okay.
Oh, also one other thing on that. I think it's important to keep in mind as well. A lot of people think, oh, if I have a court proceeding that's upcoming, I've been sued, I've been told to come to court, geez, what am I going to do? If a bankruptcy is filed on that person's behalf, it creates what's called an automatic stay. The automatic stay is actually an instantaneous federal bankruptcy court order that stops all creditors from taking any action. It even stops court proceedings dead in its tracks. Like there's a myth that the IRS can do anything, collect at any time. Bankruptcy filing stops the IRS as well. So it's a very, very powerful remedy. So it's wise to keep that in mind, that the bankruptcy statute, no matter what your problems are, there may be something in there to help even what appear to be very extreme problems.
Okay. Good. I've heard that bankruptcies can be very embarrassing and humiliating to people who file them.
That really is a myth. People who file bankruptcies are treated by, first of all, their attorneys obviously treat them very well. But I think they're more worried about the court and the trustees that are involved, that somehow someone is going to sit them down and give them a tongue lashing or criticize them or tell them that they're a deadbeat or something like that. That just does not happen. It's not tolerated. The system isn't about that at all. Everyone's treated with the utmost dignity. So I think that fear is thankfully ill-founded. But I do think it plugs into something that may be almost as important. And I think a lot of people who are thinking of filing bankruptcy really feel some sort of shame about it. They feel some sort of guilt or whatnot. And that's really unfortunate because I think sometimes they really take too much upon themselves. And the bankruptcy law is there to render aid. It's even the founding fathers. In fact, bankruptcy is right in the United States Constitution. Congress shall make laws concerning bankruptcy. The founding fathers recognize that sometimes people get into difficulties they just can't get out of. And that's why bankruptcy law is needed. We don't deal with debtors' prisons or Dickens-like treatment of debtors anymore. People are treated very well.
If I file a bankruptcy, I'm probably never going to be able to get credit again.
Well, that's not true. If you don't get credit, it's because you haven't tried. There are a lot of myths about that. Another myth that sort of goes hand in hand with that, if I file bankruptcy, I'm not going to get credit for 10 years. That plugs into the law that says the bankruptcy filing can remain on your credit bureau reports for 10 years. But the key question isn't how long it stays there, it's how long do creditors hold it against you. Used to be it was 2 years and that was it. The financial meltdown in 2008 changed that. It's now about 3 to 4 years to get your FICO score back up. If you take the right measures after a bankruptcy, oddly enough, get a couple of credit cards, not high balances on them, use them for day-to-day expenses, never go more than half the balance on the credit limit. And if you use them properly, your FICO score is going to go up, and you're going to have credit your credit problems, credit score problems are going to probably be behind you in 3 or 4 years. So that is really a myth, and I think that really puts a lot of people off from bankruptcy.
One of the other things I hear a lot is that if you file a bankruptcy, you basically have to own nothing at the time. And you touched on that a little bit, but I want to just cover that a little bit more. In particular, you were talking about the exemptions.
Exactly.
And so it is a myth that you have to be completely assetless to file a bankruptcy, or it doesn't make any sense. I mean, that's
absolutely
not true.
That's absolutely the case. In fact, it's sort of sad because sometimes you have people that believe they have to dissipate their assets before they can file bankruptcy. And I see this happen all the time. I see people that come into my office, they've liquidated their 401ks, their IRAs.
Right.
And it's sad for this reason. Congress, when it enacted the laws for 401k and IRA, made them exempt from creditor claims. The idea being that this would be money people would use in their old age. Congress was saying to citizens, do not liquidate these assets. Even if you're in financial trouble, we're making them exempt from creditor claims. Don't put yourself in a position of being destitute when you're elderly. So far from being your duty to liquidate those assets to file bankruptcy, it goes against what Congress intended. Congress intended for you to keep those assets.
Right.
Moreover, to be absolutely cynical about it, if you're totally destitute, you don't need a bankruptcy. You're judgment proof.
Exactly.
Bankruptcy is for those that have too much debt. They're insolvent, but they need to get rid of the debt and preserve their assets.
Right.
But if you don't have any assets, no one's going to get anything out of you. But it is a shame to see people spend down their savings, liquidate IRAs, really put themselves, denude themselves of assets, and then come to see me. And it's sad because we could have saved so much. Mm-hmm. The saying among bankruptcy practitioners is our clients come to see us 6 months to 2 years too late oftentimes. Right. So there's no need to wait until things are totally desperate.
The other side of that is the refinancing of the house that continues and continues and continues to pay off credit card debt. They may be getting a lower rate on that refinanced mortgage, but they're eventually going to have to pay it if they're going to keep their house. So that's yet another way that people do that conversion of an asset without even thinking about it. Yeah, because the equity is going away every time they do a refi.
It really is sort of heartbreaking to see people do what we call converting unsecured debt into secured debt.
Right, right.
One of the first rules of consumer household finance, family finance, is don't turn unsecured debt into secured debt.
Right.
There are a lot of other things that can be done before you do that. It's just heartbreaking to see people whittle away what oftentimes is their biggest asset by refinancing to pay off credit card debt. Right. Thankfully, that's not happening quite as much, but we still see it happen. And refinancing for better terms, fine. No ifs, ands, or buts. Mm-hmm. Get the lower interest rate. But please, don't pay off the credit card debt, unless it's a small amount. But if it's $30,000, $40,000, $20,000, think twice before doing it. Oftentimes, a bankruptcy can be done with really very little impact on day-to-day life at all. And oftentimes, almost no impact on day-to-day life. Mm-hmm. But the impact ultimately is favorable. You're getting rid of the debt with little downside.
Right. The one thing I'm worried about, if I file bankruptcy, it's going to be published in my local paper.
I've heard that for years, and sometimes facetiously I'll say, no, but we can publish it if you want to. But no, I think of the cases I've had, I think 2 have been published because they were things of particular public interest or whatnot, and high-profile type situations. But the basic rule is no. There's no publishment in the local newspaper. Is it a matter of public record? Absolutely. But The newspapers aren't in the business of embarrassing people by listing the bankruptcy filings. The bankruptcy notices that people see in the newspapers have to do with the administration of bankruptcy estate assets, but there's no need, desire, or intent to publish people just to embarrass them.
Yeah, and with the period we've hopefully gone through, I hope I can say it that way, we have gone through.
Hopefully.
They probably wouldn't have enough room in their paper to publish them all anyway.
It would get rather boring very quickly.
Yeah, there'd be a lot of pages on them. If I file bankruptcy and my employer finds out about it, I could be fired.
That's a real myth. No ifs, ands, or buts. The number of employment positions in the United States where a bankruptcy filing jeopardizes employment is almost nil. I think it may be if you're trying to want to be on get a place on the New York Stock Exchange, sit on the New York Stock Exchange, a bankruptcy might impact you. In fact, bankruptcy law is very clear that no one is to discriminate against you adversely on the basis of bankruptcy. Now, they can use it for credit scoring purposes, but you cannot be turned into a pariah. The bankruptcy code would be a very meaningless tool if there were ways of singling you out for adverse treatment. Right. It would become a meaningless remedy.
Nobody would do it.
Right, no one would do it, and Congress and the courts are not going to let that happen.
Right. Okay, one last question. And,
okay.
I'm going to transfer my assets out of my name into someone else's, and then I'm going to file bankruptcy.
I hear this often in innocence and good faith. I've got a building lot that I own with my brother and sister, and why don't I do this? I'll deed my interest over to them, do the bankruptcy, and they can deed it back. Please don't do that. That is bankruptcy fraud 101. That would be both criminal and civil. If people think about it long enough, they realize that's not the thing to do, because technically what you're doing is putting assets beyond the reach of creditors. If that was done to you, you'd cry foul as well. If the assets are exempt, fine. If they're not exempt, sometimes that happens. Sometimes we have bankruptcy cases where people get rid of a lot of debt, but sometimes some of their assets have to go away. And I often tell people, they're disappointed in that. Say, geez, before you came in this office, if someone told you you had $100,000 in debt and you had to give up $20,000 to get rid of it, you probably would have jumped in a minute.
Right.
And if you have to give up a $20,000 asset, it's the same effect. So that would be a very unwise thing to do, to convey assets out to file a bankruptcy.
Yeah. Well, Bob, I want to thank you very much for coming in. We haven't seen you in a while, but we're going to have you come back again.
Glad to come back anytime.
Not too distant future. And for those of you out there, I want to thank you all for watching. I want to welcome our Belmont station, who is now carrying the show as well. And hope to see you all again next time.